right. What is up? And welcome back
So
to How to Invest in Commercial Real Estate. We're back.
We're back.
Braden just rolled into town, man. Just popped up here and
I did.
boom.
He was on site at our new Fort Worth acquisition.
That we are going to buy very soon. Here in a few weeks, we're going to buy it.
Yeah.
Looks good. Looks good.
Good infill deal. Fort Worth's a great market.
Yeah, there's like 5 month-to-month tenants immediately.
Yeah.
Some people look at that and think, risk when we think we can immediately
Increase rents, get them to pay triples.
Exactly.
sign long-term leases.
Yeah. And there's a really nice Sherwin-Williams out there. There's a really nice Family Dollar there. Parking lot's in pretty good condition, and everything around it's full. I mean, it's very much infill.
Yeah,
Fort
good.
Worth. So,
Rolled that deal out, a couple days ago?
yeah, it launched yesterday. Was it yesterday or the day before yesterday?
probably.
What is today? Friday. So it launched Wednesday and it filled up Wednesday.
Yep.
Like in 3 or 4 hours.
Yeah.
So, Brian, you were in Maui?
I went to
Nice.
Maui.
Awesome.
With the family, and we had a great time, did some surfing. And
Maybe Tanner can throw a pick up. And I was in the BVI last week with some really good friends, so that was super fun.
what'd you do, Braden?
Worked.
I did. That's good. I did. I'm going to Florida next week, though. So
Nice.
And
Better
so
not
and
call
so
me.
am I, Brian, so in your face.
I guess I'll hold the fort down. I'll do all the work.
Are we going to have Brian go into the office all next week since we're not there to put in his, his
I go
ownership?
in every day.
wait,
as it
you're in
is.
Florida next week too?
Well, Gulf Shores, Alabama.
Okay.
It's probably,
I'll hold it down.
you said Rosemary you're going to?
Yeah.
Yeah, so
we're
it's
close.
probably an hour and a half.
Nice. I'm going to drive. So
I've done it. It's tough.
yeah. Anyway.
All right.
Lot
Any other
going on.
updates from,
We exercised an extension option on the Texas portfolio, so we're going to close that July 20th, I think is what it is. The Fort Worth deal, Trail Lake, is filled up, but that's going to close in the middle of July as well. Several other offers out. I know we're negotiating PSA on a deal outside of Atlanta.
any closings that we have coming up pretty quick here?
That's it.
Okay.
Yeah, that's it. Yeah, so kind of in a lull. What did we just close?
Laburnum and Richmond.
Yep.
So,
And are you guys going out there with us, next week? Week after next.
Yeah, week after next.
maybe.
Yeah, maybe.
Not sure. Yeah.
I'll let you know.
That's it now.
We might be busy. We might be out of town.
Yeah. I'm going to be working. Meet David out there. I mean, it's good. He got the whole team out there.
You're next week you're in Florida?
Next week in Florida.
Okay, I'm here next week. The week after I'm in Gulf Shores. So,
Gotcha.
yeah. All right, today's topic is we're going to just give you a little hint of what it's like to be in this game. If you're in this game any length of time, you're going to get sued. And so we thought we would just kind of talk through a couple of high-level things to think about because it's always too late to think about these things once you're sued.
Yeah.
That is true. And sometimes it doesn't take too long. Like Criterion was like 18 months.
Before
18 months
sued?
and we got sued.
And it doesn't take much to get sued, right? I mean, you guys have...
It takes nothing.
You guys have lived through a few of these. What are some examples you've seen?
I swear to God, somebody not posted, but they show up to court and they sue us because they drove through a pothole allegedly causing thousands of dollars worth of damage. I'm young and ignorant at the time, so I'm just like, okay, give him a check for $1,500. It was a compelling story, yada, yada, yada. Like a year later, he comes back asking for thousands more dollars. And I'm like, hey, we took care of this. He files a lawsuit. And like what got us is he showed a picture of a pothole that was indistinguishable from anywhere.
pothole.
It could have been anywhere in the entire world as long as it was an asphalt pothole. And that was the burden of proof that got him thousands of dollars.
Well, it didn't go to trial, but did it? I don't think it did.
No, it's just a judge. So, I mean, there wasn't a jury trial, but it went to... Oh, it didn't even go before a judge. I think it was like mediation or arbitration.
Yeah, the issue, there's lots of issues with lawsuits, and we definitely encourage you guys to talk to an attorney. But once you get sued, it's pretty easy to sue somebody. Okay, that's pretty much the easy part. Just draft some documents and file. It's the cheapest part of the whole thing. Yeah. But once you're sued, then you have to contemplate, okay, how much money is it going to take me to fight and win this case? And so if someone sues you for $10,000 and it's going to cost you $40,000 to fight it, and to go to trial will be maybe $100,000. Well, you can see why you'd be motivated to just mediate and settle it because, okay, did you owe them the $10,000? Maybe not. but you don't want to spend $20,000 to show them that you didn't know it to them. So you may settle, okay, I'll give you $4,000. Can we settle it or whatever? And so it'll go away, but it still costs you money.
Yeah, and just the entire process is punitively painful for all sides because you have to pay a legal professional typically hundreds and hundreds of dollars an hour to help advise you on something you should kind of already know yourself. Like at the end of the day, we kind of already know, like, was there somebody actually wronged?
Yeah, so you cannot represent yourself if your LLC is sued. You can only represent yourself without a law degree when it's you you're defending.
I didn't know that.
You can't defend a company, an LLC, without an attorney. So that's what you were mentioning there. So it gets expensive even if the lawsuit's small. But what are some of the other concerns that you're going to have? And I've been sued a few times, and I'm actually going through one right now. And so some advice that we have for you guys is the unique thing about getting sued is that the suing party and the defendant have a right to discovery. And so what that means is that you can ask for all of this information from the parties to figure out what was going on behind the scenes.
Yeah.
Information that you didn't have access to, like emails.
So text messages, emails, handwritten notes, conversations that they can prove that you had, call records. All of that is discoverable, and for any relative person involved, any relative discussion or item, and it's pretty broad on the relevancy. Like, might it be relevant? Well, then you need to include it and provide it in discovery. And so what we want to encourage you guys to do as you're going through your business is take a stance that you're going to eventually get sued. And so be thinking ahead, number one, but two, be conducting yourself in a way that you're not afraid of of people getting a hold of your emails or your text messages. Like in this lawsuit I'm in now, I handed over everything that I had, and I was glad that I didn't put any embarrassing things in some of those emails, right? Because then it just comes out and then they can read that for everybody. And so you always want to be thinking, someone's going to read this someday in a lawsuit. I should make sure I'm professional.
Yeah, and it's a bit of cover your ass, like eventually if you get tired of people ghosting you for coffee, you develop this behavior of like checking in with people 30 minutes before your coffee meeting to make sure they show up for coffee. It's kind of the same thing. It's a cover your ass move that you develop to just restate and reaffirm things that can't be proven, like conversations, like agreements, that weren't papered up. It's just an easy way to say, yeah, I sent you this email. You clearly responded that this was fine. Years later, you can't then allege that, we had some sort of agreement. Here's this paper trail of this conversation where we were both in agreement. There was nothing owed. We were doing this. You can see the point. You can see the example.
Yeah. Another thing we encourage the people at Criterion to do is if there's an issue and maybe it's handled kind of over the phone or something, we always tell them follow it up in writing, because if we have to prove this in court, we want to say, well, look, we had it in writing, we had an agreement, and if you don't have that, then it's easy for somebody to come back on you. So we encourage
great
that.
point. So if you have a conversation and let's say a tenant agrees to not make you replace the ceiling tiles when they're moving in or something. Reason. Okay, great. Even though it may have been in the lease that you needed to do it. So the first thing you need to do is send an email that says, hey, enjoyed the conversation. I appreciated you confirming that we don't need to do the ceiling tiles. So what that does is it gives them an opportunity to respond. If they are silent, then the court will deem that your email was acceptable in their eyes, that they agreed with your email. If they don't
That's
agree,
the other thing is, like, just by them showing an email with a correct email address, it's almost like a burden of proof of delivery. You don't have to respond and acknowledge it. You were at least aware of the information.
Right. And then if they disagreed with the example of having to provide the ceiling tiles or something, then they would need to say, no, that's not how I remember the conversation. But if they just go on about their lease and they never notify you of where's my ceiling tiles, then your email covers you that you had that discussion and you were not obligated. Yeah. So it's thinking ahead like that. And I always say conversations aren't worth the paper they're not written on. That resonated with me when I was young, and I just kind of took it to heart. Like, okay, if we're having a conversation, it doesn't mean anything to anybody. And it actually never happened when it comes to the law.
And it's... to clarify, I don't think it's out of a lack of integrity. It's about the intent is there's so much going on that we're all going to misremember things. Us as humans are very unreliable sources.
Lawsuits, like we said before, they can come through years later. So you're not going to remember everything.
Like disputes over money or something that you would sue over, like you may actually forget that.
Yeah.
You know, I said I was going to pay you 8%. No, you said it was 18%. It may have just sounded the same and you were actually never on the same page to begin with. Like it's just a good behavior of memorializing things in writing. It can be text messages. I see this in signing new leases all the time. Hey, we gave you keys. Like we mark delivery and something we can prove. Hey, we gave you that space.
Mm-hmm. There is one thing, Joel, maybe you know the answer, well, both of you probably, but let's say right before a lawsuit happens, one thing they can't have in discovery is communication between you and your attorney, as long as that's considered attorney-client privilege, right?
Yeah.
And I've had attorneys tell me, write that in the subject line, because sometimes it can be it can be a little vague, so a little gray area. So if there's something you and your attorney are talking about, just in the subject line, right? Attorney-client privilege. And then
or a confidential. Yes. So the only time that your conversations with your attorney might be deemed non-confidential is if a non-affiliated party is a party to that conversation.
Correct.
So it has to be you and your attorney. Now, like with us, if we were all three meeting with our attorney and we're all part of the same LLC, then that would also constitute attorney-client privilege. But if I had a friend of mine in there and also then talking to my attorney, that conversation, if anybody found out about it, would not be protected.
I see.
Because it's now public information.
Yeah,
you know, it's not private privileged information.
Yeah, that's right.
A good example is we're working with our attorney on something right now where I needed to involve our civil engineer. Like we copied them all in one email. Hey, attorney, we need this thing prepped. Civil engineer, pop in if you need add any technical color that I don't know about. Our attorney always kicks them off the reply, which is very annoying. But you know, he's just making that privileged, confidential, private information. Very good behavior to get into, I think, in many facets unrelated to real estate. Like it's just a good behavior that you need to be in business, I would say.
Yeah, and one of the lawsuits I'm still going through, there was a discrepancy on exactly what the contract meant, and I can't believe that I am saying that I've been in this business a long time, and I'm still having issues with the wording of contracts. But I'm really not a good enough detail guy, and sometimes I don't read fully, and even sometimes the attorneys don't, and so it's very important that you understand contracts and that you take the time to understand what you're obligated to do under that contract.
Just think of everything that you can possibly think of that could go wrong and get it covered in the contract.
And then the majority of my job, I would say, is literally reading contracts.
Yeah, I know you do a lot.
But in any event, I think one last comment on lawsuits is it can be a powerful tool. If you think someone has wronged you, but you're not sure, right? You maybe don't have the hard evidence, okay? But you would love to read their emails between intercompany emails regarding the property that they sold you or whatever. Then discovery allows you to get access to those, and so know the power of a lawsuit because it can help you discover the information that you need in order to make your lawsuit effective.
Also, you shouldn't think that just because so in discovery you hand everything over, right? And just because you think, oh man, this email is really damaging, I'm gonna hold on to this one. Can't they, if they think that you haven't given everything over, can't they hire a service to go through your emails anyway?
Yes, they can. And a good example of that is not to give any names, but a lawsuit that I have been in, we had to hand everything over, and we handed over some things that I didn't really want to hand over. Yeah. Right? It wasn't all positive for me. There's some things that could have been interpreted another way or the wrong way, but the law requires you to do that, and that's a definite sketchy game if you're going to try to withhold things that you think aren't relevant, but somebody else might think are relevant. And so, once again, if you're operating with the right premise and staying professional and doing the right things behind the scenes, then you don't have to worry about getting sued down the road because you're not going to have anything to hide. And that's the best position to be in.
Yes. I think the good practice is going through business with a sort of historian mindset because we have no idea what we're going to be accused from a decade from now, right? And it's going to be some crazy shit that's going to be very hard to remember. And you just hope that you have, it's going through your email, it's typing in keywords, it's typing in names, it's typing in things. And it's just like, man, I really hope I sent an email memorializing that thought because you always have this feeling. It's like, I know we agreed on this. I know this was the thing. Like, I specifically gave you this for that. How could you think this? Yeah. And it's just so easy. Write it down, send it to him, text, email, whatever it is, handwritten note. I guess it can be as easy as that. You've got to be in the habit of doing that. I think the most one we do all the time is late rent. Because we as landlords can't file for an eviction unless we've given legal notice that we've demanded for our payment. It's so dumb. Like it's so dumb. But you have to send a demand before we sue. So a lot of the times we'll have payment arrangements worked out with the tenant. They get the demand letter and they're like, hey, I thought we talked about this thing. It's like, yeah, that's true. But if you fall through, then this covers my tail because you knew that I was demanding the money.
Well, good stuff. Just to give a high level to keep you guys open-minded. If you're going to be in this game long enough, you're going to face lawsuits. We want to make sure that you're protecting yourself as you go along, but also to know what to do when you do get sued. Consult an attorney. They have all the advice you're going to need. We definitely do not. Yeah. Hopefully you can go years and years and years without any lawsuits. That would be the best. But
yeah, and the other thing is don't forget to kick it over to your insurance. I know we're talking about business and company lawsuits. It's really important that you kick these over and at least notify your insurance carriers. General liability most of the time is what picks it up. Because if you don't notify them timely enough, sometimes they can have a right to reject the case altogether.
Yep. All right, guys. That's the show for today. Till next time.
Thanks.
All right.